The House Judiciary Committee will come to order. Madam Clerk, will you please take attendance?
Chair Breen.
Present.
Representatives Edwards.
Here.
Carter.
Here.
Hope. Here. Arbit. Stevendorf.
Here.
Hoskins.
Here.
Cerniglu.
Here.
Fink. Wenzel.
Here.
Wozniak.
Here.
Outman.
Here.
Johnson.
Here.
Madam Chair, you have 11 members present. You do have a quorum.
Thank you. I will take a motion from Representative Edwards to approve and adopt the minutes from the previous meeting. And those minutes are now adopted. We have a busy committee today, and I do know that we have some members that are still in another meeting. I've assured them that we will save all the exciting stuff for later so they have time to get here. We will be going through several different packages of bills. This will be what I presume to be the final Judiciary Committee hearing of the term. So saving all the fun stuff. I'd say we're saving all the fun stuff for last, but we're not. We did a lot of stuff at the beginning of this term for sure. We're going to take testimony and vote out House Bill 6259, Senate Bill 688, Senate Bill 813, House Bill 4198, House Bill 6183 through 85. There are also two bills that were not listed on the agenda. They are properly before the committee. These bills were inadvertently sent to the wrong committee, and they are now back before us. They were referred to us from criminal justice. Thank you, Chair Hope. But before we begin testimony on all of these, we are going to adopt some substitutes and vote out House Bills 4504, 4505, and 5525 from Rep. Pies. We took testimony on these during our May 20th committee hearing. These bills have now been, am I good so far? Yeah, okay. There's a lot, guys. These bills have now been fixed. They have addressed concerns regarding penalties, vets, and other stakeholders, handlers, and these bills are now in pretty good shape. So, beginning now, do I have any cards to read in? For the Pies bills. Are we good?
Yeah, here.
Okay.
No.
One's
We're doing
5404 and 5405. Are there any additional cards?
I don't see them.
We're good? Okay. If anybody did submit testimony, we love written testimony, and that will be recorded and attached to the committee minutes. So, and if you did submit anything electronically, those will be attached. I have H1 substitute for House Bill 4504 before the committee. I will take a motion from Representative Edwards to adopt the H1 substitute. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit. Stevendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink. Wenzel.
Yes.
Wozniak.
Yep.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 11 yeas, 0 nays, and 0 pass. The substitute is adopted.
I will now take a motion from Representative Carter to report House Bill 5404 as sub H1 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit. Stevendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink. Wenzel.
Yes.
Wozniak.
Yeah.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 11 yeas, 0 nays, and 0 pass. The motion prevails.
I now have an H1 substitute for House Bill 4505 before the committee. I will take a motion from Representative Hope to adopt the H1 substitute. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit. Stevendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink. Wenzel.
Yes.
Wozniak.
Yeah.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 11 yeas, 0 nays, and 0 pass. The substitute is adopted.
I will now take a motion from Representative Devendorf to report House Bill 5405 as sub H1 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit. Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink. Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 11 yeas, 0 nays, and 0 pass. The motion prevails.
Thank you. We have an H2 substitute for House Bill 5525 before the committee. I will take a motion from Representative Hoskins to adopt the H2 substitute. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit. Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink. Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 11 yeas, 0 nays, and 0 pass. The motion prevails.
Thank you. I will now take a motion from Representative Cerniglu to report House Bill 5525 as sub H2 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit. Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink. Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 11 yeas, 0 nays, and 0 pass. The motion prevails.
Thank you. We are now going to turn to House Bill 6259. This is a bill that fixes an error that was made in the original legislation, House Bill 4416. And in that bill, it stated, and guys, I know this is riveting, absolutely riveting stuff. It was stated that the trust distribution to the beneficiary must be for a material purpose of the trust before the beneficiary would be entitled to trust notices and accountings, with the intent, in part, that trust could be efficiently administered by not requiring notices to remote contingent beneficiaries. Now, I'm sure everybody totally understands all that. Anybody who's an expert in probate law, maybe Representative Wozniak over there, loves this. But there are some ambiguities in that language. And so this bill clears up these ambiguities, creating certainty for people who are practicing in this fascinating area of probate law. We do have somebody, if necessary, if there are questions, available to answer any. Does anybody have a question on this bill? No? Rep Wozniak, you've got nothing?
I've read it,
You're good?
yeah. about-
Okay.
I'm okay.
You're okay. All right. I'm going to read in some cards. Regina Bell, not wishing to speak, supporting the bill from the Council of Michigan Foundations. The Attorney General is supporting this House bill. And we have the Michigan Nonprofit Association also supporting the bill. Seeing that, I will take a motion from Representative Edwards to report House Bill 6259 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit. Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink. Wenzel.
Yes.
Wozniak.
Yes.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 11 yeas, 0 nays, and 0 pass. The motion prevails.
Thank you. We are now going to turn to Senate Bill 688 regarding juvenile records for research. And I know Senator Chang is probably in the Senate, but we have her amazing legislative director, chief of staff, her everything, I guess. Ellen, why don't you talk to us about Senator Chang's bill, please?
Sometimes I park her car too. I mean,
You're a great staffer. I'm sure very much appreciated.
thank you, Chair Breen, committee members. We're grateful to be here to talk about 688. These are like basically all my favorite House members here. So Senator Chang was approached by Wayne State University School of Social Work, the Dean Cheryl Kubiak, who's been a leader on juvenile justice efforts about passing this bill. Last year, as you guys remember, we passed historic reforms to our juvenile justice system that were recommended by the Juvenile Justice Task Force. They move us forward to a smarter system where we give more young people a better chance to succeed by using evidence-based screening tools, get more youth into diversion programs. It's important that we are able to collect data and evaluate the impact of these changes. So the purpose of Senate Bill 688 is to allow for a juvenile diversion record that has been redacted of personally identifiable information to be collected by a court official and provided to a researcher or program evaluator for the sole purpose of a research request granted by SCAO or by scale. The juvenile diversion record would still have a unique identifier such as a case record number, petition number, or other unique identifier as determined by the court and researcher. Personally identifiable information in this section is defined as information about an individual that would reveal their name, date of birth, social security number, address, and other information unique to individualism. If the request is granted by the court official, the involved parties will negotiate a data use agreement that will provide personal identifiable information from, it will protect personal identifiable information from public disclosure. Where there's no unique identifier may be found, the state court administrative office may work with the researcher to match the records and then de-identify the data for the goal of completing the research. In the Senate, we addressed some concerns and adopted a substitute that included changes that were agreed upon by SCAO and the Wayne State University. So those changes involved including both researchers and program evaluators, leaving flexibility for the court and researcher to determine the appropriate method of privacy protections as long as it prevents public disclosure, explicitly exempting the data from FOIA since it's housed by the court or SCAO, and explicitly authorizes SCAO and the court to release the records if a data use agreement is reached. Researchers and program evaluators need to access this data to be able to analyze juvenile diversion efforts and evaluate whether the state is reaching the intended outcomes of the package of bills we passed last year. I'm now going to turn it over to Dean Kubiak from Wayne State, who's joined us on Zoom.
Dean, are you there?
Good morning. Yes, I am. Thank you.
Thank you. It's the dean at my alma mater. Hi.
I appreciate the opportunity to talk with you. And as Ellen said, this bill allows integration of data across systems. As you know, juveniles, in terms of intervention and prevention, are often linked into community service providers where they are either mandated or supposed to complete a term of service. And the outcomes of whatever that diversion program is cannot be assessed by courts or local communities because you cannot link the court records with the treatment or service records currently. So this allows that connection to be made so that we can then return data to the municipalities, to the courts, to say, this is what's working and for whom. And that allows us to run our state and our counties more with data-driven efforts rather than having to guess or anecdotal data. So this is not a bill that just provides access to Wayne State. It is a bill that allows program evaluators from across the state to work with both courts and treatment programs to put that data together so that we can actually assess the efficacy of programs and the changes that we've made.
Thank you for this. I also note that I'm very proud of the work that our entire legislature has done for juvenile justice reform. Chair Hope has been quite the leader on that. Thank you. Do we have any questions for these witnesses? Nope. Oh, I'm sorry. Representative Johnson.
Thank you, Chair Breen. Can you just give me a little background as to what led up to this need for the changes, like an example?
I think I'll let Dean Kubiak give you an example of something that they would be studying using these data use agreements.
So in the juvenile justice legislation, there's more of a turn towards diversion efforts to keep youth out of detention. So say a judge orders a community organization like GrowthWorks to provide services to an individual. And that might be 20 weeks of treatment or therapy. What the court doesn't ever know, does that youth complete the treatment? And did that treatment connect to any decrease in recidivism or offending or disruptive behavior? And so this would be example of saying, here's the court mandate. Here was the treatment that was ordered. This was actually what was received. The youth was successful in meeting the compliance of the court. And then looking at a year later, let's say, did that individual stay out of the juvenile justice system? Did that individual complete whatever other mandates that the court made? But right now, we have never been able to link the program data and the court data. And so that the judge or the referee may not know the outcomes of what they've asked the youth to participate in. Does that help? Does that make sense in terms of how that would be connected?
Thank you. I don't see any additional questions. And I forgot to say this at the beginning of the hearing, so I'm going to say it now. Moving forward, for anybody testifying, we're going to ask that you keep it to 3 minutes so that we can get through everything. If you have requested to speak on a particular bill and there isn't enough time, I encourage you to submit written testimony. Okay. I'm now going to read in some cards. We have a card of support, not wishing to speak, from the Michigan League for Public Policy, attributed to Ann Coonan, Kids Count Policy Director. Jennifer Peacock with the Michigan Center for Youth Justice, supporting House Bill 688. And the State Bar of Michigan, also supporting House Bill 688. Senate Bill. Thank you, Maya. We have a H1 substitute for Senate Bill 688 before the committee. I will take a motion from Representative Hope to adopt the H1 substitute. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arbit. Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Pass.
Wenzel.
Pass.
Wozniak.
Sure.
Outman.
Pass.
Johnson.
Pass.
Madam Chair, you have 7 yeas, 0 nays, 5 pass. The substitute is adopted.
Thank you. I will take a motion from Representative Devendorf to report Senate Bill 688 as sub H1 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes. I'm sorry.
Carter.
Yes.
Hope.
Yes.
Arbit. Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Pass.
Wenzel.
Yes.
Wozniak.
Sure.
Outman.
Pass.
Johnson.
Pass.
Madam Chair, you have 7 yeas, 0 nays, and 5 pass. The motion prevails.
Thank you. We are now going to turn to Senate Bill 813 from Senator Cherry. We have Nick Haas from the Senator's office here to testify. Welcome. Please. Oh, you've got some people joining you, too. Are you Lori from the Children's Advocacy Centers? Okay, we'll get to you guys in a minute. I think we have cards. All right, Mr. Haas, please tell us about the bill.
Good morning, Chair Breen, members of the Judiciary Committee. On behalf of Senator Cherry, thank you for taking up this measure. The bill before you, Senate Bill 813, would allow for minor victims and vulnerable adults to have their video recorded statement used in lieu of in-person testimony for only pretrial proceedings in certain abuse and sexual abuse cases. The intent of this bill is to allow for these particularly vulnerable victims not to have to go through the re-traumatization of giving their testimony at a pretrial proceeding. These victims, as many of you know, are particularly vulnerable to re-traumatization. There can be a lot of psychological effects for having to relive for what, for most of them, would be the worst moments of their lives. In addition, there's also several provisions in this bill that establishes the process for sharing a copy of the video with the defense. In a lot of ways, these provisions codify current practices. In these instances, we are talking about a video that is shared with the defense under strict protective orders. For the defense to share this with their client would essentially be jeopardizing their law license or be subject to strict penalties by the court. So we believe this is not just an honor system thing. This is holding these attorneys to a very high standard. And it also establishes the process of who may testify in hearsay in the case where a video recorded statement is not recorded by the advocacy center in a particular county. And after that, I will turn it over to Lori and Melissa from the Child Advocacy Centers to highlight the importance of this legislation.
Hi, welcome. Introduce yourselves before you start speaking. Thank you.
Yeah. Good morning, Chair Breen and committee members. Thank you for allowing us this time. I know your time is very short. I'm Melissa Workman. I'm the CEO of the Children's Advocacy Centers of Michigan. We represent the 40 child advocacy centers across the state. And I'm joined here this morning by Lori Kirchhoff, who is Executive Director of the I Am Safe Child Advocacy Center for Montcalm and Ionia counties. And we instigated or introduced this bill principally because we want to do what we can to mitigate the re-traumatization of children who are asked to testify strictly in the preliminary hearing. Re-traumatization is very frequent when children are asked to testify and again face their accusers. Allowing this to happen and the recording of the forensic interview to be introduced at preliminary hearing in lieu of a child's in-person testimony does help to decrease the psychological distress that children may go through when they are asked to once again face their offenders in court. We do a lot of work through mental health services, victim advocacy, and other supports at our child advocacy centers in order to get them on the path of healing as soon as possible. Asking them to come and testify, again, face their accuser when we have a reasonable opportunity through the recording of a forensic interview would go a long way to help mitigate that re-traumatization. It does impact also a child's memory and credibility, as well as the severe long-term impacts it can have on learning, psychological development, and their overall well-being. I'm going to turn it over to Lori to speak a little bit more about the work of the CACs in this role, as well as some of the more legal aspects of the bill.
Thank you. Thank you all for having me here today. As she indicated, as the executive director, I've been in that position for 9 years, and our center has seen over 2,500 children who have been victims of sexual abuse, severe physical abuse, and or human trafficking. More importantly, prior to this position, I was a chief assistant prosecutor for the Ionia County Prosecutor's Office. For 14 years, I worked in that office, and I handled primarily these cases where these children had to go in and do the pretrial conferences, pretrial meetings, motions, and the preliminary exam, which is what we're talking about here today. I've seen firsthand what these victims have had to go through and testify at a probable cause hearing where it's not necessary. In this particular case, we're not talking about a trial. The defendant will still have a constitutional right to confront his victim at the trial. We are talking about in this bill preliminary exams, pretrial motions, things that happen before the trial where it is not necessary for a child to come in, be re-traumatized, and have to testify. The videotape that we're asking to be introduced is considered reliable. It is a videotape that is actually made at the Child Advocacy Center. When the child first discloses, they're brought to the center immediately. They do this interview with a person who is unbiased, who is forensically trained in the interview process, and it is done so with law enforcement, CPS, and prosecutors who are present, but in a separate room so that they're not there to intimidate the child. So this is the best circumstance for a child to come to a center that is friendly, that is able to deal with them in a trauma-informed way, to solicit and get that information from them without asking leading questions. So it's the best evidence that you would have and be better for a preliminary exam and pretrial purposes as opposed to a child being intimidated and placed on the stand by a defense attorney and having to testify. So again, this is not going to hurt the defendant in any way. They'll still have their constitutional right, but This will help the child in the long run, and that's what we need to do. What's the best interest of the children? We've seen too many cases that are going through where children are not getting the justice because they're being forced to testify repeatedly as a defense tactic so that they can get these cases dismissed. So I'm asking that you support this bill, and I'm happy to answer any other questions as well.
Representative Wozniak.
Thank you, Madam Chair. How many instances, or who actually violates this type of statute? I mean, is it the public defender or the attorneys or the judge? Who violates these rules?
The rules being with the, we're talking
With the
about
penalties.
Okay, so if this were to be violated and they were to actually violate the protective orders that are put in place by the judge, we're talking about the defense attorney themselves, who are members of the bar, who have to step forward, obviously, and their credentials are at risk if in any way they do not follow those protective custody orders. So that's who we're talking about, who would be in violation if it,
Have you seen that happen?
never. I've never seen that happen in my personal experience.
Okay, so this is more like a guideline, a guardrail.
Yes. In this particular case, defense attorneys are already getting access to this information. This is not new. They are guaranteed to be allowed to get this information under the discovery rules. So they're already currently under the practice of getting these transcripts, if they exist, or the video recordings, and letting their clients see them. Judges are already standardly issuing orders where they're stipulated to by defense attorneys and prosecutors, which allow them to have copies themselves with those protective conditions that are already in play in this bill that indicate they have to return it. This is already happening. We're just codifying it and making it now into a law. And so in this particular case, you're not changing any of the practices that are already happening. So, but you would be changing the fact that a child would no longer have to testify. And that's really what's key here today, is getting that videotape introduced for the preliminary exam instead of the child testifying. Which, I just want to comment, preliminary exams and other pretrial hearings, there are rules of evidence. And hearsay is part of the rules of evidence, in which there are many exceptions out there that allow people to introduce evidence without a child testifying or without a witness testifying in those cases. For instance, domestic violence cases, when a victim is a victim of a sexual assault, when she makes that report and the police come out and take her statement. That statement is admitted later at a preliminary exam without that victim testifying. It's called an excited utterance. We also allow doctors to come in and testify when they treat victims. They can come in, and the history that they take and the statements they take from that child are admitted under an exception, under the medical exception for hearsay. So again, there are lots of things that are already saying that you can get statements in, but not for children in these particular cases. So if they're already allowed in other cases where we know the standard is simply to have a probable cause hearing, it should be admissible in this case to allow those videos instead of the children.
And, yeah, I liken the hearsay rules to the Chair Breen's favorite rule against perpetuities. Thank you.
Thank you.
I just want to clarify, this does not replace or change anything as far as the ability to have the child testify during trial outside any other exemptions.
Absolutely not. This is very specific. It says pretrial and preliminary exams. And so this is not at all for the trial. You can still obviously impeach a child with a statement or a video, but this is not going to replace that testimony. They still have their constitutional right to call that child to the stand and have them testify.
I find hearsay exemptions much easier to understand than the rule against perpetuities. Representative Outman.
Well, thank you, Madam Chair, and thank you all for being here, especially you, Lori. I know firsthand just all the great work you do at I Am Safe. Just a kind of a technical question on the process. I'm not an attorney, bring a very ignorant perspective to this committee. So walk me through the preliminary examination. I mean, and I think you touched on it, is the sole purpose of that just to determine if there's probable cause moving forward? I mean, what does that look like?
The sole purpose is it's a checks and balance, basically, in the legal system for the defendant. So we already know that a warrant is issued in the beginning by a magistrate who reviews it. We know this case has been investigated by law enforcement. Prosecutors reviewed it. We have that all accumulate now into a warrant that's issued, and then we have what's called as a preliminary examination. During that preliminary examination. It's a probable cause hearing where the judge himself makes the decision as to whether or not there's enough evidence to say, yeah, something probably happened here, and to bind it over to circuit court so that they can in fact have their trial, their day in court. So it's only being viewed by the judge in this particular case. He's the one making the decision, not by a jury. And so it's just a probable cause hearing where they have to give enough evidence to say, yes, I think something happened. We can still go forward. They weren't falsely arrested.
Thank you.
Yes.
Representative Fink.
Thank you. I have to admit, I'm struggling with this a little bit. Obviously, people who abuse children are guilty of, some of the most heinous acts that our criminal law punishes and should punish. On the other hand, even in the testimony today, I think the danger here is that we're skipping a step. I mean, I think we heard testimony talking about how we'd be requiring children to face their offenders in court, but these are people who are, at the time we're talking about, presumed innocent. And so calling them offenders even kind of collapses the entire, which I think is kind of where the resistance, I imagine, from the defense bar would come from, that you have obviously extremely sympathetic witnesses and not allowing for the confrontation even at the preliminary exam, could generate a sort of a prejudicial decision. I think I presume that's the concern that the defense bar would raise. So I have a couple of kind of technical questions, and I'm sorry to say I didn't have the chance to do as much research on this as I would like to, given that our agenda was changing up until last night or maybe even this morning. So I haven't had as much time to dig into this as I wanted to. But do you think that is there a case that says that the confrontation clause does not prevent this kind of testimony from being admitted at the preliminary exam stage?
So the preliminary exam is a statutory creation that has come up. This is not constitutionally guaranteed to any defendant. And so the only constitutional agreement that they have is at the trial phase. And at the trial, that constitutional right kicks in for them.
But does a defendant, for instance, have the right to counsel at a preliminary exam?
If they choose so.
Do they have a right to it under the Constitution?
At the preliminary exam?
Yes. Is it a critical stage for purposes of the right to counsel?
It is not a critical stage.
So do they have a right to counsel or do they not? I mean, can the court put a defendant through a preliminary exam, and if the defendant asks for an attorney at that stage, say, no, we're going to keep going and you don't get an attorney?
If they request an attorney at that stage, then they will be granted one and they can go forward. The judge would not go forward without an attorney.
And that's a Sixth Amendment right, isn't it?
So, yes.
So I guess I'm struggling with the concept that a defendant could say, I'm not going through this prelim without my Sixth Amendment right to counsel being satisfied, but we can say we're going to go through prelim without your Sixth Amendment right to confrontation being satisfied.
But the Sixth Amendment is giving them the right to counsel to be represented. It does not extend then to any witnesses testifying in the right to confrontation. So we do that all the time. We have other witnesses come in to testify without the actual person who made the statement, and that's where those hearsay exceptions are coming in at the preliminary exam.
But are those hearsay exceptions, those are the traditional, again, I haven't done the research on this, so I am asking you. Sure. Like the Crawford case, which I think is currently still the dominant case on confrontation clause. I mean, this is the main thing we would look at, right? Doesn't that case say that you have to have that the exceptions to hearsay have to be the traditional common law exceptions, and you can't kind of make up new ones?
No, and the Crawford case does not extend to the preliminary exam. I just want to be sure we're clear on that.
It explicitly says it does not, doesn't it?
Correct.
Okay.
It does not apply to the preliminary exam. But in this particular case, they are not denied the opportunity to have witnesses and look at those statements ahead of time. They're getting all the information and the evidence. This is just an opportunity for the judge to make a decision, is there in fact evidence to bind it over? It's not the opportunity for the defendant to come in and challenge that evidence, so to speak, and say that this is where his trial is. The trial comes later. This is only a preliminary stage, a probable cause hearing.
But the defendant does have the right to cross-examine whoever does testify these
Representative
things, right?
Fink, I think it's been asked and answered at this point.
Well, I'm not trying to give her a hard time. I'm really trying to understand, because what we have here is a question of, I guess just to put it this way, if a defendant is not given the opportunity to cross-examine a witness at the prelim, it has to be more likely they're going to be bound over than if they had the opportunity to cross-examine, isn't it?
You know, it depends on the evidence that the prosecution has. It's not always dependent on just the victim's statement. And so the evidence is very minimal that is needed to get these bound over to circuit court. And so this is really just an opportunity for the judge to view that evidence. They do get a chance to cross-examine and ask questions of any witnesses that do take the stand, and they can call their own witnesses if they wish to. It is very unlikely that they're not bound over, to be honest with you. Most of these are, by the time they've been vetted 3 times at this point, by the time they get to a preliminary exam stage. So at that point, it's very likely they're going to be bound over. It has happened where they haven't been, but in this particular case, it is not a constitutional right for the defendant.
My final question, and again, I'm not trying to give anybody a hard time about this, I'm really trying to understand, is does the judge have any obligation to kind of screen the situation for coaching or coercion on the, like, do they have to do anything? Obviously, this is the role that the defense attorney would play if the defense attorney is cross-examining a witness. But given that there's no cross-examination, if we just do the video testimony without live testimony, does the judge have any obligation to take any steps to ensure there hasn't been coaching or coercion on the part of, somebody coaching a child witness?
The actual bill itself indicates there are conditions in place for the recording to actually come in. One of those is making sure that procedures are typically followed, and those procedures are following the forensic interview protocol, which is through the governor's task force in the state of Michigan. So the person doing the interview has to follow those, and in that process, there is a process where they do ask the children certain questions to make sure that they are a person who can tell the truth in this particular case, they know the difference between the truth and a lie, and that they're not going to say something that's untrue during that interview process. So all those things are in play to ensure the reliability of that statement from that child, and so that's automatically going to be happening with every interview.
Thank you.
Last question, please, I hope.
She just said something that triggered. Under the forensic interview protocols, if the interviewer steps out of that parameter, is that admissible?
If the interviewer does not follow the forensic interview protocol, then a defense attorney can file a motion indicating that they feel the statement is no good, and it's called a taint hearing they have. And so that's a separate pretrial hearing they could have to call a witness in. There's lots of different motions that can be filed that challenge the credibility of that victim. So they could then challenge that at a later stage in a pretrial motion.
Okay, thank you.
It wouldn't be done at the prelim, though, because that's not the purpose of the prelim.
Okay. Thank you very much. I actually found that discussion pretty riveting. I'm going to seeing no additional questions. Nope, wait, hold on. Yep. We have one card from the Criminal Defense Attorneys Association of Michigan, neutral on the bill, not wishing to speak. And weren't there I think there were some other cards and electronic notices. All that will be recorded in the minutes. Okay. And I will now take a motion. We do have a statement of opposition from the treatment board. I know that, and I have encouraged Senator Cherry to continue to work with them to resolve any concerns that they have raised. I will now take a motion from Representative Hoskins to report Senate Bill 813 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Pope.
Yes.
Arbit. Devendorf.
Yes.
Hoskins.
Yes.
Cernigler.
Yes.
Fink.
Pass.
Wenzel.
Pass.
Wozniak.
Pass.
Outman.
Yes.
Johnson.
Yes.
Madam Chair, you have 9 yeas, 0 nays, 3 pass. Senate Bill 813 is reported with recommendation.
Thank you very much for your testimony and your assistance.
Thank you.
We are now going to move on to House Bill 4198 from Representative Glanville. Thank you, Representative. Tell us about your bill.
Thank you, Madam Chair, and thank you, members of the committee, for hearing this bill. So this bill is pretty straightforward. It was brought to me initially by the city of Grand Rapids after they had discussions with the urban core mayors and others. It is simply removing a preemption that would allow cities, if they so choose, to create an ordinance that would limit firearms, open carry of firearms within government buildings that they own or lease. I'm proud to have various law enforcement agencies, I believe, in support of this. And just a kind of a fun story after all that. When this bill was initially enrolled, my husband, who is my number one gun advocate, said, "What are you trying to do, ban guns?" I said, "No, I'm not banning guns." And he had gotten a text from a friend, and I was like, "That's not what we're doing in this bill." And so I went back and read the bill and realized that there was an error in the language. So you have before you a sub that cleans that up. And no, we are not banning guns. We are simply allowing cities, if they so choose, to create an ordinance, again, that limits open carry in government buildings.
So just to clarify, this eliminates the preemption to allow local governments to control what they see in their own buildings. Well, not
Yes.
control what they see, but it just removes the preemption.
Exactly.
Okay.
But there is an allowance for law enforcement to be able to carry so that they are able to do their jobs.
Okay. Do we have any questions for the representative? Representative Johnson.
Thank you, Madam Chair. How does this affect, probably what your husband was thinking of, how does it affect CPL holders?
Right. Well, it doesn't directly it actually doesn't directly impact anybody. What it does is it gives a city the option to create such an ordinance, which then, the details of that would come out in the municipality.
But the ordinance can only apply to open carry or to anyone, concealed or open carry?
It would allow a local unit of government to prohibit the open carry of firearms inside a government building owned or leased by the local unit of government.
So only open carry, not
Yes.
concealed. Okay, thank you.
Representative Fink.
Yeah, was there an incident or anything like that involving the legal open carry of firearms that was the impetus for this legislation?
Yes, my understanding is that in the last few years, the need for protections within the buildings in terms of having not only police officers in uniform but also out of uniform to witness meetings. The level of threat and violence has gone up in our city meetings, and so we have had to extend significant resources on keeping those buildings protected. And the folks who are trying to do their jobs there. So this was out of a concern for safety, number one, and then also, again, the cost, not only in, basically human resources. I mean, we need our police officers, to be on the streets doing the work that we need them to do, not sitting through committee meetings.
Well, we have them here. Is there any,
No, we do.
and we have metal detectors, so I don't
Yes, we
know that
do.
you're going to save the police officers' time, but is there a incident involving
I'm
some-
not aware of a particular incident that this is in reaction to. This is a request on the behalf of, again, this came to me through various mayors who had the same concern. And I believe, like I said, there are numerous law enforcement agencies, or groups that are in support. I think we have some cards on that. So
Do you think there's any downside to having different rules in different places? So if a person is used to going to public meetings, open carrying, obviously that's...
I'm not sure my personal opinion applies here.
Well, you're a legislator. I mean, we're all here expressing our opinions. My question is, do you think that there's any danger of having a patchwork of different rules in different municipalities on, the essentially the practice of a right that's in our state constitution?
No.
Okay, thank you.
Representative Hope.
Very quickly, I think that danger could be obviated by posting a sign
Yes.
on the outside of the building.
Representative Cerniclu, did you have a question?
Thank you. I think I had some discussion with law enforcement about them wanting a bill like this so that it could be banned in their departments. Is this kind of addressing what they...
My understanding is yes.
Okay, great. Yeah. No,
I'm sorry, I can't speak to
sounds like
every
that.
specific incident that this might apply to. As I said, and as Rep. Sunerglou mentioned, this is a request that is coming from folks who are in the position to implement this, and they are asking that this be an option. And again, it is an option for a city. It would have to go through the municipal process to create the ordinance and go through all of those checks and balances before it could be enacted. But this is the folks who lead our cities and who protect our cities are asking for this opportunity to potentially have these kinds of ordinances. So again, it's not a strict it's not a strict control over anything.
Thank you. We have some people who do wish to speak in opposition, and so I would ask that you stick around just in case we need you. I'm going to ask that these two people come up at the same time, just for the sake of trying to keep things moving smoothly. Nick Bugia, I'm sorry, Bougie? Bougie. I am so sorry if I butchered your name. I'm so sorry. As well as Jason Gilman. Nick, I believe, is here representing the NRA. Jason Gilman on behalf of Michigan Open Carry. I don't care who goes first.
Okay.
But thank you for coming, and let's go.
All right. Thank you. Thank you for allowing me to testify today. This bill is simply just bad policy. I'm Nick. I'm with the NRA. So this bill is simply just bad policy. Preemption laws protect citizens' rights, and they help create a clear understanding of the laws surrounding firearms so that everyone, no matter where they live or travel in the state, have a clear understanding of the law. Citizens' constitutional protection or protected Second Amendment rights should be preserved at all costs, as should all the rights afforded to them under the Constitution. Preemption laws help ensure that states have the final say when it comes to firearm laws in the state, and that citizens' rights are not eroded by arbitrary lines on a map. It also creates confusion when laws vary widely within a state, potentially placing otherwise law-abiding citizens at risk of violating an ordinance of which they were not previously aware as they travel within the state, or more so for visitors who travel to our state. Allowing cities, townships, counties, and the state to all regulate firearms differently places an unfair burden on law-abiding gun owners and on the law enforcement tasked with this enforcement. This is why almost every state today has a law prohibiting local jurisdictions from imposing gun control restrictions that are more severe than state law. Thank you.
Thank you. Mr. Gilman?
Excuse me, Madam Chair. Thank you for giving me the opportunity to speak today. I'll be brief. Obviously, Nick here talked about the actual problem of closing up preemption. However, there are some other key issues. One of these issues is that if you're under 21, you cannot get a CPL. Therefore, carry for anyone under 21 would be prohibited for any of these municipalities that decided to so choose to ban open carry. That poses some potential issues. The other two issues kind of go hand in hand. The big thing here is that there's no definition of what constitutes open carry or what constitutes concealed carry. The People v. Phillips case of 1996, basically it was an unpublished opinion, but the court ruled that inside the waistband carry still constituted concealed carry. Yet, you'd be in a situation where someone might be doing that with a CPL, however, they would get stopped for open carry. That's certainly a concern, and then this could obviously affect inner city minorities as well. That's the key thing. And then in terms of safety that was brought up, what's the difference in safety between someone carrying a firearm openly versus concealed? There is absolutely none. It's clear the anti-gunners don't know and they don't care. Thank you, Madam Chair.
Any questions for these witnesses? Representative Edwards.
Could you elaborate more? You said something in regards to it would affect inner city children. Can you elaborate on that a little more?
Not necessarily inner city children, ma'am. Just potential issues with inner city minorities possibly facing extra scrutiny.
In what ways?
Just for example, in a situation like, for example, I talked about the People v. Phillips case. From what I recall, it was a situation where a minority was observed at a gas station in an inner city with inside the waistband carry, and it could be argued he was targeted as a result of that, whereas it might not happen elsewhere, but it appeared to have happened there. So that's a potential concern with a bill like this.
So you're talking about one situation regarding the whole state of Michigan, right? Just one situation.
Well, I also use this situation to touch on the point of no definition between open carry and concealed carry except being handled by the courts as a trier of fact.
Okay, thank you.
Any additional questions? Representative Johnson?
Thank you, Madam Chair. I can't remember the statistic, but what is it if some of these areas became known as gun-free zones? There's a stat about the increase in violence in general in gun-free zones. Can you?
I wouldn't have any particular statistic off the top of my head, but keep in mind, ma'am, this only prohibits open carry purportedly. So, and that obviously, again, brings up the concerns of anyone under 21 not being able to carry in these areas because they can't get CPLs. However, those with a CPL would still be able to carry concealed.
Any additional questions? Okay. Thank you very much for your testimony. I'm going to read in some cards. Supporting the bill, not wishing to speak, Karen Farah, City of Grand Rapids. Supporting the bill, not wishing to speak, Harrisana Richards from the Michigan Municipal League. Supporting the bill, not wishing to speak, Judy Allen from the Michigan Townships Association. Supporting the bill, not wishing to speak, Matt Saxton from the Michigan Sheriff's Association. Opposing the bill as written, not wishing to speak, Catherine Boussard as herself. Opposing the bill as written, not wishing to speak, Bill Whitbeck as himself. We have some additional comments and testimony submitted electronically that will be reflected in the minutes. And we are now going to move on to voting. We have an H1 substitute for House Bill 4198 before the committee. I will take a motion from Representative Edwards to adopt the H1 substitute. Madam Clerk, please call the vote.
To adopt the H1 substitute for House Bill 4198, Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Pope.
Yes.
Arbit. Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Pass.
Wenzel.
Pass.
Wozniak.
No.
Outman.
Pass.
Was that a pass?
Yes, sorry.
And Johnson.
No.
Madam Chair, you have 7 yeas, 2 nays, 3 pass. The substitute is adopted.
I will now take a motion from Representative Carter to report House Bill 4198 as sub H1 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Pope.
Yes.
Arbit. Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
No.
Wenzel.
No.
Wozniak.
No.
Outman.
No.
Johnson.
No.
Madam Chair, you have 7 yeas, 5 nays, and 0 pass. The motion prevails.
Thank you. We are now going to turn to House Bill 6183 through 6185. That would be Representative Puri, Representative Young, and my own self, Industry Accountability, to introduce the bill package. We have Representative Puri here to testify, and I believe we have Kelly Sampson, Senior Policy Counsel at Brady. And we have this and then one more package to get through in the next 25 minutes. So again, I'm going to ask everybody to keep their testimony brief, keep questions brief, and I encourage any and all offline conversations, again, as well as any testimony submitted electronically. Thank you. Representative Puri.
Very good. Thank you, Madam Chair and members of the committee, for the opportunity to testify today. I'm speaking to you today to urge the support of House Bills 6183 through 6185, legislation that would help the state of Michigan and victims of gun violence hold negligent actors of the gun industry accountable for their misconduct. This bill would allow victims of gun violence and impacted communities to hold the gun industry accountable for irresponsible practices that have for years created dangerous conditions in the state of Michigan. Since 2005, a federal law called the Protection of Lawful Commerce in Arms Act, also known as PLCAA, has provided gun manufacturers, distributors, dealers with special protections from civil liability that really no other industry in the United States has. But the protections here, though they are broad, they're not absolute. The statute contains exceptions that provide a roadmap for states to strengthen their laws in ways that create a pathway for some level of accountability for the industry. And since 2021, 9 states have enacted these laws around our country to ensure that they could hold bad actors in the firearm industry to account. And I think what's important here is that all attempts to strike down these laws through courts have proven to be unsuccessful, so these laws remain on the books in these states. And so as it stands currently, 1 in 3 Americans live in a state in which these laws have been enacted, and so Michigan can follow suit. By enacting laws such as House Bill 6184, a gun industry member is not shielded from liability when their conduct violates state law. And this law can help move the gun industry toward important safety innovations, and the proof is just really out there. When you look at other industries, for example, being here in Michigan, when you look at the automotive industry, industry oversight and accountability has led directly to safety innovations such as seatbelts, airbags, and brake lights. And we do the same. With holding other industries accountable, whether it be the opioid manufacturers or vaping companies. But for me, the crux of it is that I believe the gun industry should not be held to a lesser standard than any other industry, particularly given the dangerous and deadly nature of their products. Michigan, unfortunately, is no stranger to devastating shootings. From daily gun violence to unintentional shootings to mass shootings, the violence is widespread, and really, we're at a point right now that no one bill or idea can alleviate all of that and all of those issues. But this will just help ensure that bad actors in the gun industry can be held accountable for their actions going forward and giving justice to future victims. But importantly, this will incentivize firearm manufacturers and dealers to implement safety measures to ensure that the guns they sell are safe as possible and that those firearms do not fall into the wrong hands and potentially be used to take innocent lives. On average, in Michigan, over 4,400 people are shot and killed or wounded every year. As I said before, the gun industry should not be above accountability while Michiganders pay for both financially and with their lives. This legislation will pave a way for that accountability for bad actors and encourage just more responsible behavior for all those involved. Thank you again for your time today.
Thank you. I just want to make sure I understand this correctly. The way, at least I personally look at these bills, is these aren't about the Second Amendment so much as consumer protection, and that the industry should be held to the same standards as any other industry if their product harms someone. That's just my interpretation of these bills. I'm wondering if that's something that you agree with.
It is, right? I don't think that this is as much as a question of revolving around the Second Amendment as it is consumer protection.
Thank you. I know, Representative Fink, I know you have a question, but I'm wondering, can you wait till after Kelly Sampson testifies?
Oh, yeah.
Okay. All right. Thank you. Ms. Sampson.
Thank you, Chair Breen and other distinguished committee members for allowing me to speak on this important bill. My name is Kelly Sampson, and I'm Senior Policy Counsel at Brady. I'm also a native Detroiter who wants to protect Michiganders from gun violence, and that's why I'm honored to support House Bill 6183 through 6185. Right now, gun manufacturers, dealers, and distributors play by a different set of rules than every other industry in this state, and these bills simply enable the public or attorney general to hold gun industry actors accountable for their own conduct. Let me give an example. Say that a man named John Doe goes to a gun store with his grandma. Only John shows interest in guns and interacts with the clerk. But when it's time to complete the background check, John slides the form over to his grandma and she completes it. This screams straw sale, and a reasonable seller would know that. But this seller lets John walk out the store with the gun that his grandma bought. The next day, John uses that gun to kill his wife. Now, John would face criminal charges and possibly civil suit. But unless these bills pass, the gun shop could evade responsibility because of the Protection of Lawful Commerce in Arms Act, or PLACA. PLACA has in many ways shut the courthouse doors to those who have been injured by irresponsible gun industry actions that would otherwise be actionable under ordinary civil justice principles. To be clear, PLACA is not a total immunity law, but many courts have wrongly interpreted it that way, creating precedent that now binds us. These bills correct PLACA's unintended overreach by ensuring that the gun industry faces the same legal standards as we all do. These bills neither create strict liability nor guarantee a favorable judgment, and all of the protections against frivolous suits apply. Responsible gun industry actors have nothing to fear from this law. But gun industry members who irresponsibly, negligently, or recklessly manufacture, sell, or market firearms should be held accountable. These bills simply make that possible. And I'm hoping to answer any questions you might have about this very important bill, and on behalf of Brady, we urge you to adopt it. Thank you.
Thank you. Representative Fink.
Thanks, Madam Chair. Attorney Sampson, I think I just heard you say that the manufacturers can escape liability because of PLACA, and these bills could help correct that. But how could that be true under the supremacy clause of the Constitution? If it's a valid federal statute, we can't do anything about the protections that PLACA gives to manufacturers or sellers, right?
Yes, and that's a great question because PLACA has 6 exceptions, and one of those exceptions says that if a person violates a state law applicable to the sale of firearms, then they're allowed to have a lawsuit. So part of what this statute does is create reasonable controls in the state of Michigan. Therefore, it fits into that predicate exception.
Okay. What other states have adopted similar legislation?
Maryland, New York, Delaware, California, I'm trying to think of all the other ones. Hawaii, Illinois. So 9 other states.
Okay, and or 8 states in the district?
Yes.
Yeah. What can you give any examples of any of the lawsuits that have actually been brought, especially any lawsuits brought by a state attorney general?
Yes. So in the state of New York, the attorney general and the city of New York both sued a gun store on the accusation that the gun store did not act reasonably in the way that it sold firearms. In the state of Delaware, their attorney general opened an investigative inquiry into a gun store that basically, the way that they stored their ammunition was almost advertising for individuals who want to steal it. And so they had multiple thefts. One person alone in the state said that she stole ammunition from that store 20 times, and they did nothing to change the way they stored their ammunition. So the Delaware Attorney General is currently investigating and may bring suit according to their state law. And then in New Jersey, their Attorney General is also bringing a lawsuit against a gun store.
Okay, and then my final question would be, if these are really, I mean, if the intent here is essentially to just bring the firearms industry under the basic Consumer Protection Act that Michigan has, then I can understand why Representative Breen's bill would be necessary because of the specific liability shield, but I don't understand why why House Bill 6184 would be necessary. In other words, why are we creating a special cause of action for firearms manufacturers and sellers if it's essentially just trying to bring them in line with the Consumer Protection Act generally?
It's not trying to bring them in line with the Consumer Protection Act.
Okay, I didn't think so either. That's helpful. Thank you.
So much as it's actually putting them in line with tort law. So regular tort law in the state says that you have a duty of care, that if you act irresponsibly, you can be held accountable. But there was a provision of Michigan law that basically said that's true for everyone but the gun industry. So one of these statutes repeals that, and then it says the gun industry is now on the same playing field as every other industry.
Which again explains 6185, but it doesn't explain 6184 because you're creating a special cause of action just for firearms sellers and manufacturers. So
That's because of PLACA. So because of the predicate exception in PLACA, 6184 is basically a law that applies to the sale of firearms.
But I guess what I'm saying is, it is not the case that this is just going to be like any other tort. We have different rules, and they're all specific to the firearms industry, right?
No, I think where it's slightly confusing is that this actually still doesn't put the firearms industry on the same plane as every other tort because of PLACA. So that's why you have this one law that says if you have reasonable controls for the sale of firearms, you now can be liable. But if the firearms industry was going to be like any other tort, then you would be able to have pure, simple negligence.
Okay, I have a feeling that I'm not actually going to get any more questions here, but I guess the point is, isn't one of the challenges here that firearms are inherently dangerous? They're supposed to be dangerous. That's what they're for. And so, I mean, for instance, are there any other products where we would allow a cause of action against the seller or manufacturer, notwithstanding any intervening actions like the unlawful actions of third parties?
I love that question because it gives me a chance to clarify. This actually is about the intervening actions. This is not about the intervening actions of a third party. So in your example, let's say that someone goes to a gun store, there's no indication of a straw sale, there's no indication that anything about that sale is unusual, they pass a background check, and then they go and do something. That's not what this is about. This is about the case like what I described, where the gun store does something unlawful. The gun store does something irresponsible, like allow a straw sale, or like putting firearms in the window instead of behind a secure case. So these cases are really about what the gun dealer or manufacturer does, not about what someone else is doing wrong.
But if a dealer of any other dangerous good did the exact same things that the firearms seller did, and then a person, say, stole, irresponsibly stored dangerous products of some other kind and committed a crime with them, would there be liability on the part of the seller?
Most likely, yes. I mean, they would have to go to court and play it all out. But for example, you can be liable if you overserve someone. So there are many examples where it's about what the gun dealer is doing. And what we've seen, and maybe this will allay some of the concern, when we see these cases come up in other states that have passed these laws, you do not see a flurry of frivolous lawsuits at all. Because it's a very specific set of circumstances. And from the latest data that we have, 90% of gun dealers don't sell a single crime gun. So most gun dealers are following the law, they're being responsible, but this is about that minority that are really acting irresponsibly. And we're saying that they should be held accountable for what they do, not for what other people do, just like all of us.
Thank you, Madam Chair.
Thank you. That was a very good back and forth, and I personally feel enlightened, and I feel even better about voting these bills out. I would ask that you stick around. We have testimony from 2 more people. I'm going to have to keep it very, very brief from everybody as we have one more package after this. Nick Bougie, I believe I got it right this time, if you would like to come and testify. And then we will go to some testimony in Zoom and take some votes and then go to their final package.
All right. Again, thank you, Madam Chair, members of the committee, for allowing me to testify today. These bills directly undermine PLACA. Supporters of this legislation say that firearms are the only product that have blanket immunity from liability. That is untrue. PLACA simply provides the same rules that apply to most other industries. For example, even though it's foreseeable that people will drive recklessly or under the influence, the car industry is not responsible for these things simply because they lawfully make and sell cars. The illegality of the driver's actions break the chain of causation. This is the same protection PLACA provides to the firearm industry. Furthermore, under general principles of tort law, a person is not responsible for the acts of a third party unless that third party is under the person's direct care or is controlled by the person as an employee and is acting within the scope of employment. If a firearm dealer, manufacturer, distributor, etc., could be sued every time an unaffiliated criminal uses one of its guns unlawfully, you would no longer have a functional gun industry in the United States. And that's exactly what the supporters of this legislation are aiming for. That is not to say that the firearm industry is untouchable. Under PLACA, illegal conduct by an industry member that results in harm is still actionable. That is also true here in Michigan, where the law only protects sales that comply with MCL 28.435 and any other applicable law of the state and applicable federal laws. So, for example, if a dealer were to sell a firearm to a consumer, knowing the person was prohibited violent felon and the felon went on to commit a violent crime with the gun, the dealer could still be liable. What these bills seek to do is nullify PLACA and make what is legal in the realm of gun sales a moving target. For example, a dealer could be in perfect compliance with the law in selling an AR-15 to a 22-year-old man who nevertheless goes on to use it in a crime. Under this bill, a plaintiff could try to convince a judge or jury that it was unreasonable to sell a military-style assault weapon to a young man because young men in general are known to be hot-headed, impulsive, and easily influenced by violent images, movies, and video games and advertising. Never mind the AR-15 was legal, that the customer passed a background check, that all paperwork was properly filled out, and that nothing about the customer's behavior portrayed any instability or illegal intent. If such a suit were to succeed, dealers would then be on notice of a judge's created rule about selling AR-15s to young men, even though the legislature never passed such a law. The truth is, these bills don't remove some special protection that the firearm industry has. In fact, these bills place an unfair burden and responsibility on the firearm industry that is not seen in other industries. If these bills pass, the state would be placing its thumb on the scale, potentially halting the firearm industry from functioning in the state and stripping Michigan citizens from being able to avail themselves in their Second Amendment rights. It is for these reasons I ask you to oppose these bills. Thank you.
3 minutes and 4 seconds. Thank you.
Thanks.
No, that was really helpful. I'm just gonna very quickly say also that this could be true of any other suit. I think anybody could bring a lawsuit for anything. That doesn't mean anybody's going to be successful. There are definitely legal standards that have to be met by plaintiffs, by defendants, and I think this levels the playing field. We have very brief testimony from Lori Lieb on Zoom. Are you with us, Lori?
Yes, here I am. Thank you. Thank you, Chair Breen and distinguished members of the House Judiciary Committee for the opportunity to speak with you today. My name is Lauren Lieb, and I've been a gun violence prevention activist for 25 years. My activism began, as it does for so many people, in response to my family's personal experience with gun violence. In the summer of 1999, a heavily armed neo-Nazi attacked a Jewish community center in a suburb of Los Angeles. He entered the building with multiple firearms and high-capacity magazines and began shooting. His barrage of bullets lasted less than a minute, during which time he shot about 70 rounds and multiple people were shot. He was expecting to send a message by massacring an assembly of Jewish adults. Instead, he encountered small children who were attending summer day camp. My 6-year-old son was one of the children in the line of fire. He was hit multiple times, and my 8-year-old son was one of the other 200 children who witnessed the chaos and terror that day. After leaving the JCC, the shooter murdered Joseph Aledo, a Filipino-American postal worker who was on his route delivering mail. Thankfully, my son survived his physical wounds, but for both of my children, my family, and my community, the emotional scars will last a lifetime. This particular experience is uniquely American. After the shooting, we joined with other families to sue the gun manufacturers that engaged in dangerous and irresponsible business practices related to the manufacture, marketing, and distribution of the shooter's firearms. We filed our lawsuit in 2000, but the gun industry fought us for 5 years, all the way up to the Supreme Court, to stop the case from going to trial. The Supreme Court ruled to allow the case to move forward, but little did we know that Congress had also been looking at firearm industry lawsuits like ours. That same year, in 2005, Congress passed the Protection of Lawful Commerce in Arms Act, or PLACA. Not only did PLACA protect the industry from new lawsuits, but it impacted cases like ours that had already been filed. PLACA shielded and continues to shield bad actors in the gun industry from most civil lawsuits, and was retroactive to our lawsuit, which was finally to come to trial. Just like that, the manufacturers who acted irresponsibly or dangerously were off the hook. My family and other victims of the JCC shooting rampage no longer had recourse through the courts. To say it was infuriating and unfair is an understatement. Our nation is founded on the belief in equal justice under the law. No American should have courthouse doors slammed in their face because the industry that harmed them is given special protections by Congress. That's not equal justice. It's not fair. It's not right. Representative Puri agrees, which is why this critical legislation is so important. The gun industry knows their business practices create unacceptable risks for the American public, but without fear of repercussions, there is no incentive to change. There must be a way to hold them accountable for their role in the hundreds of thousands of people impacted every year by gun violence, those injured, killed, their loved ones, and their communities devastated by gun violence. This bill will ensure that victims and survivors like me and my children have access to justice. Thank you to Representative Puri for your dedicated work on this issue. I urge your colleagues to vote in support of fairness and in support of House Bills 6183 to 6185. Thank you.
Thank you very much for your testimony. I am very grateful that your children survived. That must have been horrific. I don't see any questions. Representative Arbit, do you have the quickest question in the world? I do. Okay.
Ms. Lieb, I just wanted to thank you tremendously for being here, for speaking out. I have always found meaning in the principle of our tradition, pikuach nefesh, the idea if you save one life, you've saved the whole world. And you being here speaking out in favor of this legislation about, I see this as a legislation too against anti-Semitism. And I really appreciate you sharing your experience and the experience that unfortunately too many of our communities have gone through in this country. And it means a lot.
Representative Arbit, can you ask your question? No, it's just a statement? Okay. Thank you so much. I'm so sorry. I don't like to interrupt, but we got to move. Okay. I'm going to read in some cards or briefly outline what's in these cards. Not wishing to speak, neutral on the bill, Michigan Sheriff's Association. Supporting the bill, not wishing to speak, Prosecuting Association of Michigan on 6183. We have multiple cards in support, multiple cards against, and anybody who submitted written testimony or comment, it will be recorded. I will now take a motion from Representative Hope to report House Bill 6183 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arvet.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
No.
Wenzel.
No.
Wozniak.
No.
Outman. Johnson.
No.
Madam Chair, you have 8 yeas, 5 nays, 0 pass. The motion prevails.
Thank you. I will now take a motion from Representative Arbit to report House Bill 6184 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arvet.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
No.
Wenzel.
No.
Wozniak.
No.
Outman.
No.
Johnson.
No.
Madam Chair, you have 8 yeas, 5 nays, 0 pass. House Bill 6184 is reported with recommendation.
I will now take a motion from Representative Devendorf to report House Bill 6185 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arvet.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
No.
Wenzel.
No.
Wozniak.
No.
Outman.
No.
Johnson.
No.
Madam Chair, you have 8 yeas, 5 nays, 0 pass. The motion prevails.
Thank you. We are now going to turn to House Bill 6222 and 6223. I was going to go down there to testify, but I'm going to stay right here and ask that Tony Buffa from Sheriff Mike Bouchard's office come up and talk to us about these bills. I would like to note that these bills originated from something that was brought to being by Sheriff Mike Bouchard of Oakland County. These bills are an effort to align state prohibited gun purchaser laws with federal laws, making other offenses felonies with fines up to $1,000 or imprisonment for up to 2 years or both. We've added a notification requirement that the gun seller, if somebody attempts to purchase a firearm and they are already prohibited from purchasing a firearm, sellers must notify local law enforcement of the attempted illegal purchase within 24 hours. That is the intent behind these bills. Mr. Buffa, if you could please talk to us about these.
Thank you, Madam Chair. I'll be very brief. I know you're short on time. The chair did a great job of explaining what the bill does. I would just like to take a second to explain why we think this is necessary. So, for the last year on record, federal NICS checks resulted in about 112,000 denied transactions. ATF referred about 12,700 of those denied purchases to their field divisions for investigation, and only 12 out of those 12,700 cases were actually prosecuted by U.S. attorneys' offices. So we're talking about way less than 1% of cases that were ultimately prosecuted. So that's the crux of the issue that we're trying to solve. This bill would allow state and local law enforcement to step in and use some of our resources to pick up that slack. We view it as a crucial common sense bill for public safety here in the state, and would encourage a yes vote. Thank you.
Thank you. Just to clarify for the committee then, these are people who are they are not supposed to have firearms. They attempt to purchase, and from what I understand from the sheriff is that they need to know if these individuals who are not supposed to have firearms are actively trying to procure them. And with that notification requirement, this will allow local law enforcement to quite literally go after people who are exhibiting red flags.
That's correct.
Okay. Do we have any questions from the committee? Okay. Mr. Bougie, we are out of time. I have noted that your opposition is here. Oh, I'm sorry, you're neutral. My bad. Thank you. I appreciate that. You do wish to speak. I'm wondering if you can submit written testimony instead, as we are out of time. We also have supporting the bill, not wishing to speak, Mike Schauger, President of the Michigan Fraternal Order of Police. We have, I believe, additional cards in support and in opposition, But with that, we have an H1 substitute for House Bill 6222 before the committee. I will take a motion from Representative Hope to adopt the H1 substitute. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arvid.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Pass.
Wenzel.
Yes.
Wozniak.
Pass.
Outman. Johnson.
Yes.
Madam Chair, you have 8 yeas, 0 nays, and 5 pass. The substitute is adopted.
Thank you. I will now take a motion from Representative Hoskins to report House Bill 6222 as sub H1 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arvid.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Pass.
Wenzel.
Yes.
Wozniak.
Pass.
Outman.
Pass.
Johnson.
Yes.
Madam Chair, you have 8 yeas, 0 nays, 5 pass. The motion prevails.
Thank you. We have an H1 substitute for House Bill 6223. I will take a motion from Representative Cerniglu to adopt the H1 substitute. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arvid.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Pass.
Wenzel.
Yes.
Wozniak.
Pass.
Outman.
Pass.
Johnson.
Pass.
Madam Chair, you have 8 yeas, 0 nays, 5 pass. The substitute is adopted.
Thank you. And I'll take a motion from Representative Carter to report House Bill 6223 as sub H1 with recommendation. Madam Clerk, please call the vote.
Chair Breen.
Aye.
Representatives Edwards.
Yes.
Carter.
Yes.
Hope.
Yes.
Arvid.
Yes.
Devendorf.
Yes.
Hoskins.
Yes.
Cerniglu.
Yes.
Fink.
Pass.
Wenzel.
Yes.
Wozniak.
Pass.
Outman.
Pass.
Johnson. Madam Chair, you have 8 yeas, 0 nays, 5 pass. The motion prevails.
Thank you. We have no absent members. Before we conclude, I would like to express my absolute thanks and gratitude to my legislative director, Rachel, to Maya Lowry, our amazing policy advisor, our committee clerk, Melissa Sweet. Thank you especially over to Minority Vice Chair, Representative Fink, as well as my colleagues on the other side of the aisle. I know that this term has not been easy in many ways. And also thanking my colleagues over here on the left. We have accomplished many, many great things this term. I'm very proud of the work we've done. And thank you to everyone who's been patient throughout these hearings, as well as my colleagues. I very much appreciate all you guys. Maybe I'll be back here in 2 years. I don't know. But it's been a pleasure, everybody. Thank you.